Οπότε να καλέσω στο πάνελ τον κύριο Χρήστον Κληρίδη, τον Νικόλα Κωνσταντινίδη και την Έλληνα Καβαρτή. Λοιπόν, το πάνελ μας, το πρώτο, αφορά στην λειτουργία της ανεξάρτητης υπηρεσίας δικαστηρίων, μιας πρότασης που έγινε από τους εμπειρογνώμονες από το 2018 και έπειτα. Έλαβε μέρος η Ευρωπαϊκή Επιτροπή, το Συμβούλιο της Ευρώπης και όλοι οι τοπικοί θεσμικοί παράγοντες. Και τον Ιανουάριο του 2023 παρουσιάστηκε η πρόταση για δημιουργία της ανεξάρτητης υπηρεσίας δικαστηρίων. Να πω έτσι περιληπτικά, και μετά θα έχουμε online όταν φτιαχτεί και τον εκπρόσωπο του Συμβουλίου της Ευρώπης, τον κύριο Τικράν Καραπεδιάν, και τον εκπρόσωπο της Ευρωπαϊκής Επιτροπής, τον κύριο Άγγελο Μπίνη. Προς το παρόν θα συζητήσουμε με τους εκλεκτούς και εκλεκτές συναδέλφους εδώ από μια ανάγνωση της πρότασης που έγινε για την ανεξάρτητη υπηρεσία δικαστηρίων. Βλέπει κάποιος ότι η οποία είναι διαθέσιμη διαδικτυακά, μπορεί να την εντοπίσει κάποιος. Υπάρχει, αυτά σημειώνουν τα σημεία που μου έκαναν εντύπωση. Υπάρχει ένας αριθμός περίπου 800 ατόμων που εργοδοτούνται στο κυπριακό δικαστικό σύστημα. Μου έκανε εντύπωση ότι δεν υπάρχει τμήμα ανθρωπίνου δυναμικού. Διαχειρίζεται ένα budget γύρω στα 45 εκατομμύρια, το 75% είναι μισθή. Είχα γίνει 3 προτάσεις και ο κ. Κληρίδης μετά μπορεί να μας πει περισσότερες λεπτομέρειες, εφόσον είχε λάβει μέρος τότε ως πρόεδρος του Δικαιωτικού Συλλόγου. Η τρίτη πρόταση, που ήταν αυτή που υιοθετήθηκε, ήταν να δημιουργηθεί ένα καινούριο σώμα που θα ονομαστεί Ανεξάρτητη Υπηρεσία Δικαστηρίων, και η οποία θα είχε ευρύτερη συμμετοχή εκτός από δικαστικούς, όπως δικηγόρους, ακαδημαϊκούς κτλ. Και προβλέπει πρόταση για ένα 15μελές διοικητικό συμβούλιο, στο οποίο θα προεδρεύει η πρόεδρος του Ανώτατου Δικαστηρίου και θα αποτελείται επίσης από 4 δικαστές του Ανώτατου Δικαστηρίου, τον πρόεδρο του εφετείου, έναν διοικητικό πρόεδρο, έναν πρόεδρο ενός ειδικού δικαστηρίου, τον πρόεδρο ή την πρόεδρο της Σχολής Δικαστών, τον Γενικό Εισαγγελέα, έναν εκπρόσωπο του Παγκύπριου Δικηγορικού Συλλόγου, έναν εκπρόσωπο του Υπουργείου Οικονομικών, έναν εκπρόσωπο του Υπουργείου Δικαιοσύνης, έναν εκπρόσωπο των χρηστών των δικαστηρίων, όπως αναφέρεται εδώ, και το CEO, δηλαδή τον Γενικό Διευθυντή, Γενική Διευθύντρια. Και επίσης να πω στα εισαγωγικά ότι οι κύριες αρμοδιότητες αυτής της ανεξάρτητης υπηρεσίας δικαστηρίων, η οποία θα συσταθεί με σχετική νομοθεσία, όπως προβλέπει η πρόταση, είναι να εξετάζει και να διαμορφώσει και να χαράζει την πολιτική και τη στρατηγική σχετικά με τη λειτουργία των δικαστηρίων, να επιβλέπει το έργο του ή της διευθύντριας και να εγκρίνει ετήσια ή εξαμηνιαία στρατηγικά πλάνα και σχετικές άλλες στρατηγικές. Ο ρόλος του CEO θα είναι να διαχειρίζεται την καθημερινότητα της διοίκησης των δικαστηρίων, να επιλύει όλα τα προβλήματα, να κάνει εισηγήσεις, να ξέρει τις ανάγκες, να κάνει εισηγήσεις για προσλήψεις προσωπικού κτλ. Και το άλλο που με έκανε εντύπωση είναι ότι το action plan για υλοποίηση αυτής της ανεξάρτητης υπηρεσίας προέβλεπε μέχρι τώρα, δηλαδή μέχρι το τέλος του 2024, να έχουν γίνει πάρα πολλά βήματα, όπως να έχει ψηφιστεί σχετική νομοθεσία, να έχουν αλλάξει σχέδια υπηρεσίας αρκετών λειτουργών κτλ. Και από την πρόσφατη συζήτηση που έγινε, που είχα λάβει μέρος στο Ανώτατο Δικαστήριο, φαίνεται ότι υπάρχει καθυστέρηση. Το Ανώτατο Δικαστήριο, όπως μας έχει λεχθεί, έχει κάνει τα δικά του βήματα που έπρεπε να κάνει και τώρα περιμένει από άλλες κρατικές αρχές για να προχωρήσουν. Και έχουμε εδώ, όπως είπα, τους συναδέλφους, και θα ξεκινήσω από τον κύριο Κληρίδη, να μας πείτε πώς ζήσατε αυτή την πρόταση, ποιες ήταν οι εισηγήσεις. Θεωρώ ιδιαίτερα σημαντικά τα θέματα της ιεραρχίας, ποιος θα παίρνει τις τελικές αποφάσεις και επίσης θέματα budget, θέματα προπολογισμού. Επειδή και αυτό είναι ένα θέμα που παρουσιάζει δυστοκία, δηλαδή να ζητούνται κονδύλια, να μην εγκρίνονται από το Υπουργείο Οικονομικών κτλ.
Ευχαριστώ πολύ. Καταρχάς, να ευχαριστήσω το Πανεπιστήμιο Λευκωσίας και τον κύριο Νικόλα Κυριακίδη προσωπικά για την πρόσκληση αυτή, στον θεσμό αυτόν ο οποίος φαίνεται έχει καθιερωθεί τα τελευταία χρόνια. Χρήσιμος θεσμός, ο οποίος συνδράμει, όπως είπε και ο αγαπητός Αχιλλέας, στην βελτίωση της δικαιοσύνης, της κουλτούρας για τη δικαιοσύνη γενικότερα. Για πρώτη φορά είχαμε έρθει αντιμέτωποι σαν Παγκύπριος Δικηγορικός Σύλλογος με την ιδέα του Court Service, της Υπηρεσίας Δικαστηρίων, τον Ιανουάριο του 2021. Είχε προηγηθεί, όπως πολύ σωστά έχεις αναφέρει, Νικόλα, η έκθεση των Ιρλανδών εμπειρογνωμόνων για θέματα ευρύτερα της δικαιοσύνης, αφού ακολούθησε την έκθεση του Ανωτάτου Δικαστηρίου, έκθεση Ροδοκρίτου, όπου είχαν διαπιστωθεί οι καθυστερήσεις στην απονομή της δικαιοσύνης και μέσα σε αυτή την έκθεση του 2018 το Institute of Public Administration, IPA της Ιρλανδίας, είχε διαπιστώσει ότι το ανώτερο δικαστήριο και ο αρχιπρωτοκολλητής, οι οποίοι διαχειρίζονται τα θέματα των δικαστηρίων και της υπηρεσίας των δικαστηρίων, είχαν αποτύχει στο ρόλο τους. Και όχι μόνο είχαν αποτύχει, αλλά είχε δημιουργηθεί επιπρόσθετο πρόβλημα για το γεγονός ότι οι δικαστές έπρεπε να αφιερώνουν τον χρόνο τους στην έκδοση δικαστικών αποφάσεων και στην εκδίκαση υποθέσεων και όχι σε θέματα που αφορούν τη διοίκηση των δικαστηρίων. Πολύς πολύτιμος δικαστικός χρόνος αναλώνεται πάνω στο θέμα της διοίκησης. Και όπως λένε και οι θυμοσόφοι, όταν κάνεις δύο δουλειές, γελάς της μιας. Και ασφαλώς αυτό ήταν εις βάρος της διοίκησης των δικαστηρίων με τα αποτελέσματα τα οποία έχουμε. Να δούμε το δικαστήριο της Λευκωσίας στην κατάσταση την οποία βρίσκεται εδώ και πολλά χρόνια. Δεν ξέρω αν θέλετε να κάνουμε διάλειμμα γιατί βλέπω έχετε ξένον ομιλητή.
Yes, it was my mistake. Maybe we can switch to English so that Tigran can also hear us. Tigran, are you with us?
I am connected. I hope you can hear me too.
Yes, we can hear you. Mr. Kliridis will conclude, and then we'll give you the stage to make an your introductory remarks as planned. Yes.
So
Thank you.
I will continue in English
Yes, please.
to make things easier.
Yes.
So the first meeting we had was the special committee of the IPA dealing with the matter was sometime in January 2021. The position of the Bar Council at the outset was that the administration of the courts should not rely so heavily on the Supreme Court and the Chief Registrar, and that there should be more involvement of the Bar Council in the management committee, and also other experts should be involved. As we can see in the final report of 2023 of the IPA, it is recommended that we have 4 divisions in the administration of the courts. The one is personnel, human resources, as you have mentioned. The other one is IT, technology. The other one has to do with estate management, and the other one with the finances of the university. Now, this, I think, should be reflected in the body of management. In other words, these 4 divisions with their heads should be people coming from the outside professions, so as to put their specialized expertise in the management of the courts in the 4 divisions that it was suggested that we have. This is not reflected in the recommendations for the composition of the Board of Management, unfortunately. The second point is that the Board of Management, composing, of course, of judicial representation, because you cannot exclude that, should not rely heavily, or the majority should not be the judicial voice in the Board of Management. In the light of the previous report, as I have said, of 2018 of the Irish experts, that this is not recommended. But of course, in matters reflecting on judicial procedures, the judges should have the last and final say, but not in day-to-day management of the courts, administrative, finances, IT, estate management, personnel, etc. The recommendation of the IPA that you have just mentioned, 15-member board, unfortunately, again relies heavily on the judicial input. 9 members of this suggested board are judges, judges from all levels. But knowing, and in my experience, how the system works, the final say would remain with the Cyprus Supreme Court, because the inferior judges, aspiring, of course, promotion, would hardly come into conflict on any matter relating to the management of the courts, either with the president of the Supreme Court or the other 4 judges of the Supreme Court. Okay. So at the legislative stage, and once the Ministry of Justice prepares the legislation, I think the Bar Council should make a point about not having a board with the majority, once again, of the judges, but confine their role in matters relating to judicial duties. Now, the second point I want to make is that this report also makes recommendations relating to the increased role of the registries and the registrars of the courts in dealing with preliminary matters, quasi-judicial is how I put it, duties. For example, directions that have to be given in the process of leading to the trial of a case. This is a very important matter. The Bar Council always suggested that the registrars of the courts should be involved in the administration of justice for formal matters relating to the procedure, and it's something to be followed and taken up. The third point I would like to make is that mention is made in the report in digital recording as part of the provision of the court service. Now, digital recording, as you know, as you all know, has been the demand of all lawyers to be introduced as soon as possible. When I spoke with Mr. Kokinos, who was the minister at the time relating to technological matters, he told me that the government was ready for the introduction of this technology for digital recording, but apparently there were delays. I don't know, maybe in the Supreme Court at the time, or the judicial side of the project, is something which has to be tied up and expedited with the introduction of the court service. It is unacceptable in the 21st century to still have unrecorded proceedings with the many complications that arise, objections from time to time, and the delays noted as a result of not being able to have the proceedings of the court soon after the completion of a hearing. One case I'm involved in Larnaca, there have been at least 3 or 4 delays, adjournments, sorry, because the minutes are not ready or because the judge has not been able to review the minutes and sign them and approve them. This causes further delays in the procedure.
Yeah.
And the final point that I wish to make has to do with the e-justice. An essential part of the court service, as it transpires from the IPA report of 2023, January, is that the court service should be coupled with the e-justice, a program which is much wider than the iJustice, which was only introduced as a temporary solution to the problems that we faced, especially during the period of the coronavirus. The matter of the e-justice, everybody knows. It seems it has collapsed, and it's going to take many years more to be able to go back to it or upgrade the iJustice to cover matters of the registry. And coupled with e-justice was the suggestion of the Bar Council to digitalize all files, even the pending cases, so that everything would be digitalized. The delays noted are unacceptable, as you have mentioned. This December of 2024, in accordance with the time schedule that is provided in the report, the court service should have been in operation fully. It was supposed that January 2024, the legislation would have been introduced in the House and that it would have been approved soon thereafter. So we're already 1 year behind. And 2025, next year, we're supposed to adopt the 3-year project ahead by the court service for the improvement of the court. And of course, all this is tied up with the construction of the new district court of Nicosia. I've been hearing about that since 1982 when I started my practice. I don't think it will ever happen, frankly, because there is no will on behalf of the government to go ahead with this project. The Minister of Finance considers other projects of more importance. Justice is the last in the priorities, not only of this government, but all governments, with the exception, I have to admit, with the government of Anastasiadis, who showed at least in some respects, he was more eager to help. And thanks to his aggressiveness in this matter, we now have the new Supreme Court and the new Constitutional Court and the amendment of July 2023.
Okay,
Thank you.
let me stop you here and we can come back, Mr. Kliridis, and hopefully we can change that, the last point you made about priorities. And I note your comment on composition of the 15-member board, that the majority is judges and that the judges of the Supreme Court will still have the upper hand. And let me now go to Tigran, the representative of the Council of Europe. And Tigran, if you can, in 3-4 minutes, to comment on the process of drafting this report and coming up with this suggestion. Also, if you have any comments about the composition of the board of the court service, and if you have any idea why this matter is stuck.
Thank you very much. I hope everyone can hear me.
Yes.
I can
Yes, all good.
hear myself, definitely. Do you continue to hear me?
We can hear you.
Okay, excellent. Well, dear participants, dear organizers, first and foremost, I'd like to thank you for the invitation to speak. The Council of Europe now speaks at this symposium annually, and I'm very appreciative of the opportunity to be here and to showcase the projects that the Council of Europe has done in Cyprus with this distinguished audience and on issues which are clearly of great importance to Cyprus. The Council of Europe has been implementing different projects related to judicial reforms and reorganization, strengthening of capacity of judiciaries in its member states, and actually beyond its membership. And these include projects aimed at making justice more efficient and addressing issues of delays, among other things, which I believe is the central topic of today's event. The Council of Europe has carried out technical support projects with Cypriot authorities through the implementation of important projects aiming at improving the efficiency of the judicial system. In this regard, I think a project that still deserves a mention, the first joint project launched in 2020, was focused on modernization of civil procedure rules. And the project then resulted in the adoption of the new rules in May 21 by the Supreme Court of Cyprus. In addition to that project and later other projects and activities by the Council of Europe supported the development of training programs, awareness raising, and change management recommendations. I hope that the entry into force of the civil procedure rules in September has already had some positive effect and will hopefully live up to the expectation of making the civil justice system more reliable, swift, and accessible to everyone. The second project, which was already mentioned by Mr. Kalidis, I believe, was launched in February 21, also as part of a wider justice reform process. And here I would like to mention the role of the European Commission's DG Reform, who supported both of these projects, as a matter of fact. And I would like to thank them also for the. Also, would like to thank national stakeholders for working with the Council of Europe on this, especially the Director of Reforms of the Supreme Court. The project focused on two key contributions, which was establishment of a new court service responsible for the management and administration of all courts in Cyprus, and introduction of new administrative and case management processes in the court registries. Now, we all know that ensuring that the institutional arrangements in the courts are fit for the purpose is critical to ensuring that the management and administration of the courts run smoothly, timely, challenges are anticipated and addressed, that future needs are anticipated and planned for, and that reforms are implemented in a timely manner. This was the logic, and with this in mind, with the assistance of international experts, the project evaluated key high-level processes in the governance, management, administration, and staffing of the courts in Cyprus. Then it proceeded to develop detailed proposals with options for the establishment of the independent court service in Cyprus. In addition, the project went on to then prepare an implementation roadmap, which covers the immediate actions in several stages to be undertaken in the first 3 years of setting up an operation of the independent court service. The detailed proposal and the roadmap were made to accompany a significant change in the functioning of the registries, with the aim to alleviate the current administrative duties of the Supreme Court. The project then also developed an evaluation report on the existing administrative processes and case management arrangements in the court registries, together with concrete short-term and long-term recommendations on the improvement of the internal processes, case management by the registries, and logistical arrangements. Of course, it also took into account the structures proposed to the for the new court service at the time, also the e-justice integration, civil procedure rules, and the rollout of the new civil procedure rules. The project also then analyzed some of the risks and provided change management recommendations. It's important to note that the achievement of the project's long-term outcomes and crucially its impact largely depended on and still depend on the degree of endorsement and implementation of the proposals by Cypriot authorities, by Cypriot stakeholders. And there are there are multiple simultaneous initiatives and efforts with the justice reform that have been taking place, are currently taking place, and it's important that the establishment of the court service goes smoothly and in coordination with all the other initiatives that are taking place at this time simultaneously. And I think this is maybe bringing me to another important subject, is managing the change. We've been working on the justice sectors and court management reorganization in different member states for over 20 years. In Cyprus, we've enjoyed excellent cooperation with the Supreme Court and the Director of Reforms. We managed to achieve certain things which I believe are important. And one thing I can tell you is that when we speak about court management, there are two major elements that we need to take into account. That's first of all focus on human rights, and then also focus on sustainability of any reforms. And both of these elements are in fact tied to how the reforms and how the changes are managed in general. And I think that brings me to answer maybe partially to the question that you asked. And the justice sector undergoes constant reform, which aim at making justice more efficient, effective, transparent, and these reforms normally in any country, as a matter of fact, face various challenges. So, but the chief of those challenges most often is the resistance from different stakeholders and users, and their inability or unwillingness to change their practices. Successful implementation of reforms normally requires comprehensive awareness, active involvement of all stakeholders. This is why robust change management practices need to be put in place to address essentially human behavior, which is central to managing any change effectively. And resistance may arise when users feel excluded, or stakeholders feel excluded from a reform process, think that their needs are not fully considered. Sometimes reorganization efforts also don't go so well due to lack of consultation with other users of the justice system. Listening to them, addressing their fears, concerns can in fact build the trust and ensure the acceptance of proposed changes, as well as construct those changes in a way that take into account the needs of all stakeholders. Conversely, in some cases, those who are concerned by forthcoming change are not ready to get involved in the process. So a thoughtful timeline and strategies can help conducting discussions with those affected by the change, and as a result, facilitate successful implementation of the reform. Change management in justice is a special area, as methods used in other walks of life may not necessarily face the same constraints as we see in the justice sector. The need to secure utmost independence of the judiciary, maintain impartiality, ensure confidence of users of justice services are some of those limitations that we have when we're dealing with justice. But those limitations can also turn into opportunities. So if carefully navigated, these factors can actually ensure robust and sustainable change. And that brings me also to the second element that I mentioned in the beginning, focus on the human rights in the court's management is essential for ensuring justice, equality, fairness in the judicial process. Courts serve as guardians of the rule of law, and their operations must reflect principles of transparency, impartiality, and accessibility. Human-centric approach ensures that, and human rights-centric approach ensures that vulnerable, marginalized individuals are treated with dignity, respect, that there's public trust in the justice system. This also aligns with court management, with international this requires alignment of the court management with international legal standards, promoting accountability and preventing any sort of abuses. And I think that embedding human rights principles into court procedures and administration, judicial systems can better protect fundamental freedoms, guarantee these fair trials, and most importantly, not just fair but also timely trials, so that the justice is served in time. This in turn then will uphold societal values and of justice and democracy. So these elements, in my view, should be kept in mind if we are looking to achieve success. The Council, of course, stands ready to support its member states in various aspects in managing of the justice sector. I know that my response might be a bit general after Mr. Klidis' much more detailed account. But nevertheless, I think it's an important element of the puzzle to take into consideration. Thank you very much for your attention and for the opportunity to speak here.
Thanks a lot, Tigran, for your remarks. Indeed, we expected you to be a bit more specific, but we understand your role, and that's fine. And let me now turn to Nicholas Konstantinidis, current member of the board of the Cyprus Bar Association. We were together in the meeting with the Supreme Court and the Chief Registrar a few weeks ago. Do you have any updates? And does the Cyprus Bar Association have any specific points that need to be raised in the public discussion about the court service?
Initially, let me thank you on behalf of the Cyprus Bar Association. I echo what's been said by our president, Mr. Vorkas, for this symposium, which has become an annual structured dialogue where we're able to take stock of the reform process of our court and legal system, which is a very important platform, and congratulations on doing this every year. We also want to extend our thanks to the European Commission and the Council of Europe and the IPA, the Institute of Public Administration of Ireland, for all their work, and especially the Director of Reform of the Supreme Court, as was then, Mr. Rodokridou, for leading the process in Cyprus. I think the final report provides a clear roadmap for the establishment of a new court service, and it is for the Supreme Court and the government to take lead and bring before the Parliament a draft law. And we are looking forward and anticipating in engaging in constructive discussions with all the stakeholders. We raise this as the Cyprus Bar Association with various officials at every meeting, because we do consider that a lot of the problems that we've discussed and a lot of the solutions that we all want can be unlocked with the establishment of this new court service. This is not something new, actually. From the functional review report of 2018 of the IPA, a lot of the deficiencies that we currently face from the court management system that is now in place were noted, and the suggestion for a new court service date from then. So it's very timely. There's been a lot of reform taking place in the last few years, but we need to push on, and I think the new court service will have a central role in this. the CBA is a strong supporter of this change and this development. And for us lawyers, a lot of the deficiencies that are reported in the final report come as no surprise. We're the ones on the ground. We're the ones that sustain the various severe deficiencies from a management perspective. And on behalf of our clients, we can very easily establish that there is not, at the moment, a user-friendly and citizen-focused management of the court. I think we have a court system at the moment, and with the new service, it will be changed into a court service, because we want a court system that will serve its citizens. And there are various issues that have to be tackled. The Supreme Court and the Chief Registrar and her team do not have either the time or the expertise to navigate the court system in these complex times. Exactly that, for that reason, the new court service will have a dedicated human resource department, a finance department, which will be able to tackle what you've mentioned about the budget planning and more flexibility in allocation of funds and spending, a dedicated IT department, and another very important department of this new court service, as we see it, is the buildings, projects and management department, which will be responsible to liaise with the government bodies, the responsible government bodies, both for the development of new court structures and buildings, and maintaining the current ones that we have at the moment. Development with regards I want to be more optimistic than Mr. Klididis. I understand that he's been in practice and looking forward to a new building for many years, but we have to be optimistic and push where appropriate to obtain a new courthouse in Nicosia. The government has assigned a specific amount in the budget this year for the tender with regards to the architectural drawings of this new building, and the Minister of Transport, in a meeting we had lately, has pledged to the Cyprus Bar Association to have a member on the committee that will be overseeing this project, exactly so we can have input as the majority and daily users of the court houses in Cyprus.
Yeah. Regarding the composition of the board, do you also agree that the majority should not be judges, and if not, who should have the majority and why?
I think what should be noted is that it's not necessary for a judicial majority on the governing board of this new court service. The reason is simple. I think it's been tackled in other jurisdictions as well, and we can draw best practices from countries that have developed a court system the last decades. The reason is that there will be clearly enshrined in this law that the court service will not interfere in any way in the judicial functions of the court. So the new court service will be there to provide management, administration, and support the court and its users and the citizens, and not by any way interfere in the judicial functions of the judges in the court. So from this perspective, I don't see any issue arising with regards the independence of the judiciary. So I don't think it's necessary to have a judicial majority. But of course, I think there should be a strong, substantial presence of the judges and the court personnel. But we also envisage this governing body having a broad participation from the legal community and other experts, as mentioned by Mr. Glidis as well, who can bring their expertise to the table, but also some other court users from the civil society at large. That could be representatives of the business community, consumers, or other vulnerable groups such as children or prisoners could also have a seat at the table.
Thank you, Nicholas. Turning to Elena Kabardis, from an academic point of view or from a research point of view, have you looked at other models also included in the report, like Ireland, and what are the lessons learned?
Thank you very much again for the opportunity to speak here today and on such a very interesting topic. Before I get to your answer, Nicholas, let me kind of politely disagree with Nicholas. If we look at the options that were available, and you very succinctly described them, we've seen a model that's been created simply on the basis of judicial involvement. So there were three options, as you said. A, judge-centric, without a separate agency, an agency with some form of independence, but not really in the form that was suggested. And then the third option, all of them judge-centric, because for a reason that is not uncommon to other jurisdictions around the world, the reason of what we describe as gatekeeping, the reason of institutions trying to maintain their own sense of belonging or sameness for judges themselves. So is a majority necessary? I mean, even from a reason of getting to the next step and getting the rest of the board of directors or the other branches of this service to be enforceable, I would also suggest yes. Because you need that trust and that confidence from the body that really is giving away what it perceives as power to be able to operationally proceed. So does that differ to other jurisdictions? And this report is fantastic. It's very large, but it's great. It gives out all the details in terms of Scotland, Ireland, and Norway, which are great examples to follow. There are aspects of the Cypriot judiciary, though, that are unique to the Cypriot judiciary, and I'd like to draw on them a little bit before we move into other jurisdictions. What's the basic characteristic of the Cypriot judiciary that has kept the Cypriot judiciary in the resilient form that it has, despite characterizations of increasing lack of independence potentially, or threats to competence that we've seen through many media sources? And that's its ability to maintain informal communication. Let me give you some examples through my very own research on the Cypriot judiciary. So when we speak about governance and operations of the court, what does that look like? What does that really look like for a judge? So when a judge is going into their chambers, first thing in the morning, they just walk in and they are met with a huge pile of trash that hasn't been cleaned for the last 2 weeks because there's only 2 cleaners for the entire district court. Or if, for example, a judge is serving on 2 jurisdictions at the same time, civil and criminal, in 2 separate districts. They finish their work in one district, it's around 1:30, they have to move to another district to give a judgment that's remaining. And they also have their own personal dilemmas and issues and potential personal issues, and then they have to come in. They don't have somewhere to sit to give a judgment or to kind of have a normal proceeding, and they're just standing there in the middle of the court feeling devalued. And this, perhaps, is the most important characteristic that the court service would change. And we see this in research around the world. Sometimes we treat the changes in the Cypriot judiciary as if we are the only judiciary that has difficulties in functioning and efficiency. We see countries such as the UK with the Judicial Attitude Survey saying that judges with the payment structure and efficiency structure compared to us are thinking of leaving the judiciary within the next 5 years. We see examples of the Australian judiciary with research of Macananlo and Carly Shrever telling us that judges are depressed, that they are affected operationally, that they show irritability or lack of conscientiousness, that they don't have hobbies anymore or interests, they refuse to go out in nature. And these are characteristics that we may think are linked to judicial studies and emotions, but in reality, they affect the operational efficiency of a courtroom. And so at the end of the day, this court service, as it's structured, in whatever form is necessary to be taken, is a court service that should never ignore the reality of the informal conversations that happen between judges when a new judge is appointed, or the way that they sit around or come together in the morning trying to sort out operational issues that they're going to have to discuss. And although this isn't really brought out in the report, I think it's something that really should come together, both in the composition of the board of directors, but perhaps definitely in the employees that are going to structure this body at the end of the day.
Thanks a lot, Elena. Indeed, interesting remarks, and thanks for disagreeing. It's good to have a debate. I would also like to welcome Angelos Binis from the European Commission. Angelos, can you hear us?
Yes, I can, and sorry for the delay.
That's fine. I mean, I'm expecting from you to tell us why is this project taking so long? Because the Supreme Court is telling us that they are reporting to you every other month. So probably you know why it is stuck.
I would like to share also some insights from other similar projects that we're working on across Europe, across European member states. The fact is that there is a multitude of stakeholders involved in the implementation phase and the buy-in. And I think in many cases, this is what is creating some delays on finding the most proportionate solution to address the challenges that were identified during the project. But it's not only Cyprus that is facing this kind of challenges. We're now having, for example, a very big project in France to address backlog. And again, bringing on board everybody from the judges associations, the lawyers, the Ministry of Justice on what is the best way to tackle backlog and avoid creating a new one is not an easy thing to do, from which tool to use, on which methodology. We're also doing the same project in Greece with the Athens and the Thessaloniki courts of first instance to identify what works best in reducing the backlog. So I guess that it is also the case in Cyprus between the different implementation solutions on how to make the best out of the work that was undertaken in the framework of the project. There are different options, different opinions, and this is creating a little bit some delays. But at the end, a cost-benefit analysis of the available options would yield better results, Nikos.
Encouraging that, encouraging in quotation marks, meaning that other countries are also facing delays, and also encouraging that there are discussions and we're trying to find the best possible solution. So after having all the speakers talk, I'd like to ask if there's anyone here who would like to make any comment, any remarks about the court service. Okay, then I'll go for a second round. Mr. Kliridis, anything to comment on what you heard by the other speakers?
Yes, I'm still not clear why the delay. I don't think this issue has been clarified. The matter should be with the Ministry of Justice to prepare the bill. I don't think the bill is a difficult matter. I remember when I was first introduced to the idea of a court service, I looked into the Irish bill. The act is there, the Court Service Act of 1998. It could be used as a precedent. I don't think it's so difficult to draft a bill. And I don't know if they have started drafting a bill. Nobody knows. Now, this is unacceptable, I think. There is no transparency here. Where is the bill? Are we near drafting it? Is it with the Office of the Attorney General for final remarks? So this has not been clarified. That's the first point I want to make.
Yes.
The second, Mrs. Kabardis spoke about the predicament of judges and how the court service will improve their life. What about lawyers? They suffer with this situation, despicable situation. Imagine a lawyer who has to attend on the same day an administrative court case, then a family court case, then a labor dispute, then a district court, and then perhaps on the same day a Supreme Court. This is hell. I could be a judge. I don't mind the bin being full and be there for 7 days. That's the minimum of our problems. Imagine a lawyer who contests the proceedings, what has been recorded. We have it almost on a daily basis. Things not being recorded that have been said in court, or other things are written down in the minutes. Now, it's hell for the lawyer. It's almost impossible to change the minutes. Why? Because we don't have digital recording. So I'm giving you some examples to think about the life of the lawyers, how difficult it is in Cyprus. There are many more. I could speak for hours about our problems. Now, I think the report, the 2023 report, is contradictory in this sense. It starts with a criticism of the existing system and the failure of the judges of the Supreme Court, basically, or the chief registrar, to administer and provide a modern service, court service, which it describes as unfit for the purpose. Now, you come to this conclusion, and then you end up giving the majority of running the service to judges again. This is entirely contradictory. It cannot be justified. Simply by putting in some judges from other levels, the new appeals court, the specialized courts, the administrative president, and the Supreme Court judges, doesn't change anything, because I have said these inferior judges are dependent, as the system works today, on the decisions of the Supreme Court, the Judicial Council, which is composed of the judges mainly of the Supreme Court, who will decide on their promotion. Mm-hmm. I don't see any judge coming into conflict with the president of the Supreme Court or the judges of the Supreme Court. So you still have basically a judge's management of this court service. This I don't think the Bar Council should accept. We should fight for a more open, transparent service to be provided.
Thank you. Thank you very much. Tigran, do you have any follow-up comments based on what you heard?
Well, thank you very much. Maybe one thing just to say about the report. Can you hear me still? Maybe one thing to say about the report would be that the report that criticizes the system rather than people, and then what goes on to propose changes that can be made to the system in order to achieve a better result. So I think that's a key thing to consider. I also think that some of the questions raised are probably difficult to answer by the panelists present today and should be addressed to some of the stakeholders which are notably missing in the panel. And I would like to go back to the point that I made during my first intervention, that is, any change management will require talking to all stakeholders and considering everyone's point of view. We've tried during the project, in fact, to recommend certain change management measures as well, very concrete steps. those are also included as deliverables of the project. And I would just encourage everyone to follow the advices that are there and to try to have an inclusive process and a discussion over over this matter in order to be able to achieve the result. Thank you.
Just to mention that we have invited Supreme Court, any Supreme Court judge who wanted to be here on this topic. They didn't want to attend and comment on this, and also the Chief Registrar. And I hope the reason is that, you know, they're very, you know, delicate discussions between them, and that is why they don't want to come and compromise anything. Otherwise, if it's just lack of progress, this is really disappointing. Anyway, Nicholas?
Yeah, what I would say is that the court system doesn't belong either to the judges or the lawyers, and it is not a power struggle between these two groups of professionals. Court systems belong to society, and that's why we've mentioned that this governing body should be reflective of society, and we think that a broad representation from various groups would bring the democratization, let's say, of the court system and provide more transparency. I think a point to be made with regards to the comment made by Mr. Cleridis with regards to the composition of this governing body is that something very important would be to clearly define roles and responsibilities of this new structure. So regardless of what the composition of this governing board will be, we don't want a governing board micromanaging the court system every day. So this court system, this new court service will have a CEO and a senior management team. These people who have the know-how and expertise should be allowed and given enough responsibilities and authority to manage the courts on a day-to-day basis, and this governing council should be left to provide strategy, vision, and policy decisions. So this is, I think, a good way forward. But of course, we need to see the draft law, and of course, we will be engaging in these discussions to this direction.
Thanks a lot, Nicholas. Angelos, any final comments?
Yes, thanks. 2 points on my side. First, the Commission's technical support instrument was designed as a demand-driven tool. So the ownership of the implementation belongs to the European countries. It's not up to the Commission, the way this tool was designed, to enforce implementation, but we're doing ex post evaluations of the degree of implementation, of how the project recommendations, the project outputs were endorsed, and to what extent. And this will affect the assessment of future requests, not only from the country, but also from the specific beneficiary authorities. And point two, completely agree with the panelist, Special Secretary, saying that it's not only about the judges, it's not only about the people, but also the legal professionals, the lawyers. And we're doing now 3 multi-country projects on enhancing the access to the judiciary. And I think this is the key factor for success. Include everybody early enough from the design phase, conducting the analysis, developing the recommendations, and then, of course, the implementation phase. Everybody that has a stake and is interested to find a solution for better access to justice, whether they are vulnerable groups or general population. It's not anyone competing with each other or fighting with each other, but finding the most fit for purpose solution depending on the legal background, the administration history, and the capacities of each member state. So I think the implementation should involve all early enough with transparency, and of course between the different solutions, we should take a decision and then follow up with an evaluation of whether we address the challenge.
Thank you, Angelos. And last but not least, Elena, any final comment?
I think that we have some easy solutions that we can prescribe or advocate for before the bill comes out or whenever the time comes for the court service to see the day of light. And I think one of the key persons or stakeholders in this game is our judicial college that's here with us. And for example, we see in jurisdictions around the world where training of judges of what judicial management looks like at the judicial college really helps their day-to-day experience of a judge speaking to their bailiff when they're on their phone and ignoring them, asking for exhibits. How do you confront that? That's also operational or management. Day-to-day concerns can also be dealt with by training in the judicial management setting. And so, or a very basic example that the report gives, which is that the administrative persons in charge of the courts or the districts don't meet weekly or monthly to discuss operational concerns. So if we just set up, based on like a basic business model or a strategy model that most lawyers know how to do, and we can kind of pass that down on how the operational management in courts just happens, and we combine that with training in the judiciary, I think we can help and boost the judiciary to also be more prompt and trusting in outer sources coming into the court service.
Excellent, thanks a lot. Two final remarks by Nicholas.
I just wanted to mention that the Cyprus Bar Association has reached out to its counterparts via the CCB that we participate in, which is the umbrella organization of the European legal profession. And we're engaging in discussions with our counterparts with our colleagues from other countries that have court services to get their feedback and their experience from their court services, other than Scotland, Ireland and Norway, which were jurisdictions that were analysed within the context of the report we're discussing. Denmark and Lithuania also have had recently established court services, and we look forward to getting their feedback from their experience. Just to end my participation with a positive note, we've been informed that a bill has been submitted after actions of the Supreme Court and the Chief Registrar to amend the criminal procedural law to allow digital audio recording of the criminal cases. So we look forward to reviewing that law and expressing our opinions on it. Thanks.
Okay. It's good to conclude with positive notes, although we need to see more progress on the court service project, and hopefully in 1 year from now we'll be in a position to have more things to say. Thank you everyone, Mr. Kliridis, Nicholas, Elena, Tigran, Angelos, for participation. We'll go for a break until 12:10, and then we'll continue with the session we missed before. Thank you.